Well, good morning, Jaginder Rana here. The topic for our discussion today is Directors and Officers Liability Insurance. Directors and Officers Liability Insurance. Although a company has a separate legal entity, it is obviously incapable of acting on its own and can only operate through its directors and officers. In addition to the statutory duties, and directors and officers must act in good faith in their dealings with and on behalf of the company and exercise the powers and fulfill the duties of office honestly. So it is important for companies' executives to be sensitized to the fact that virtually everything that they do creates the potential for second guessing and perhaps claim by persons adversely affected by their actions and decisions. So the Securities and Exchange Board of India has made several recommendations regarding the minimum number of independent directors on the board of listed companies and the role that they should play. So according to the code now mandated through listing agreements, at least a third of the board must consist of independent directors if the chairman is a non-executive director and half otherwise. Corporate governance often requires the executives to delicately balance the competing interests of various companies, constituents like shareholders, employees, customers, lenders, regulators, etc. So directors or officers cannot be defended by the company when legal activities are initiated against him for any reason, although he may have discharged his duties honestly or may have been ultimately acquitted by the court from the charges. As such, it becomes very difficult for a director to ensure that any negligent act by his subordinates, to whom the ultimate responsibility for the implementation of the decision is entrusted, perform their duties honestly and in good faith. So the recent amendment to clause 49 of the listing agreement by SEBI on lines of the Sarbanes-Oxley Act of USA places the directors and officers under more strenuous and stringent scanner. So historical legislations impacting director and officer suits in USA are since 1933, when Securities Act was there, then 1995 PSLRA was there, 2002 Sarbanes-Oxley Act was there. Various kind of liabilities are there. Various laws and acts, special focus on Companies Act, duty of skill and care, fiduciary duty, statutory duty, increasing the course, duty to shareholders. And then there are many exposures to publicly quoted companies, subsidies with outside shareholders, joint ventures, raising additional capital, merger and acquisitions, major restructures, international markets, private and public offerings, independent directors on board, opening branches, subsidies overseas, particularly in the USA. So the question is, who can bring an action? The potential plaintiffs are government or regulatory bodies, shareholders, employees, directors, the official receiver or liquidator, customers, competitors, public, the company, creditors. Can the company protect its directors? This is an important question, because while a company may indemnify its directors for actions brought against them, the scope of protection is limited and may well be removed if the company becomes insolvent. The company has insufficient fund, the company is the claimant, the protection is withdrawn, and they are no longer directors of the company. So most importantly, indemnification by the company is only permissible when a claim is successfully defended. Now the question is, who is protected by the policy? A policy is normally arranged in the name of the parent or holding company and provides protection to the directors and officers of that company, and also to the directors and officers of subsidiary companies Against them, alleging wrongful act, any awards are granted to the claimants against the directors and officers, including out-of-court settlement. Now, what's a wrongful act? A wrongful act is defined as any error, misstatement, misleading statement, providing relevant and concise data in form of broken slips, acts, omissions, neglect, breach of duty, breach of trust or breach of warranty of authority, employment related disputes. Means any claims to a past, present or prospective employee of the company and arising out of any actual or alleged unfair or wrongful dismissal, discharge or termination, either actual or constructive, employment related misrepresentation, wrongful failure to employ or promote, wrongful deprivation of career opportunities. Then what protection is provided? The policy provides the directors and officers against it, covers the directors and officers who commit a wrongful act in their capacity as directors and officers of the company. Legal cost in defending allegations or suits brought against them alleging wrongful act. Any awards granted to the claimants against the directors and officers, including out-of-court settlement. So, who is protected by the policy? Who is protected by the policy? What protection is provided? What is wrongful act? These have been seen. Now the question is, what type of applications could be there? What type of allegations could be there? Shareholders, inadequate or inaccurate disclosures, financial performance and bankruptcy, financial reporting, gross mismanagement rather, conflict of interest, dishonesty or fraud, investment or loan decision. Regarding employees, breach of employment contract, employment practices, liability, discrimination, sexual harassment, unfair dismissal, invasion of privacy, failure to provide a proper or safe working environment. Customers and clients, lender liability, deceptive trade practices, product or service related claims, competitors or clients, antitrust, copyright and patent infringement, business interference, product and company defamation, deceptive trade practices. Then government and regulators, dishonesty and fraud, securities violations. So principal policy features includes a scope of cover, that is cover 1, directors and officers to pay on behalf of directors and officers all loss arising out of claim for a wrongful act for which coverage applies. Cover 2, company reimbursement to pay on behalf of the company all losses arising out of a claim for a wrongful act. Then principal policy features includes policy being claim-made basis allows for indemnification of the claims made during the policy period. No right of cancellation. Claim under employment dispute also covered. Derivative action cover for pollution claims are covered. Principal policy features, few extensions are there outside directors, say crisis communication, insured versus insured, pecuniary penalties, court attendance, EPL entity cover, security entity cover, discovery period is given. Then there are minor exclusions, suggested limits are there, distinguishing advantages are there of this policy. Crime studies are showing various kind of experiences the companies have faced so far in the market. Most famous of them are Infosys case, outside board directors of claims, sexual harassment cases are there, ex-directors claims on Shubiksha case is there, Satyam fiasco was there. Thank you.